Let's just jump right into it. Today's explainer is all about the Public Liability Insurance rules. It's a really fascinating and, honestly, absolutely crucial legal framework. Have you ever driven past one of those massive chemical plants and just wondered, man, what happens to the people living right across the street if something goes terribly wrong? Well, this is the exact system built to answer that. It's the bridge between massive industrial operations and the safety of everyday people.
Here's a quick look at our roadmap. We'll be covering the no-fault liability framework, how we hold the industry financially accountable, the Environmental Relief Fund, immediate relief for victims, the shift toward decriminalization, and finally, regulatory oversight and appeals.
Okay, Part 1, the no-fault liability framework. This right here is the absolute cornerstone of the whole system. Think about traditional law for a second. If a big corporation injures you, what happens? You usually have to drag yourself through these long, painful, incredibly expensive court battles just to prove they were negligent, right? Well, this framework completely flips the script. Under no-fault liability, victims get immediate compensation, period. It doesn't matter if the owner's negligence caused the accident or not. It literally guarantees that financial roadblocks won't stop victims from getting the help they need right away.
And just to be clear, this applies to any owner handling specified quantities of some really dangerous materials right in our local industrial zones. We're talking heavy-duty, highly volatile stuff. Chlorine, ammonia, methyl isocyanate, which you might remember was the exact chemical involved in the Bhopal gas tragedy, plus a whole range of highly flammable gases and liquids. If a business crosses specific quantity thresholds with these substances, this mandatory framework immediately kicks in.
Moving on to Section 2. Holding industry financially accountable.
So having a rule that says you must pay victims sounds great on paper, right? But how do we actually guarantee the money is sitting there when disaster strikes? We really have to ask ourselves, just how much insurance is enough? Because industrial accidents can literally level neighborhoods. A basic run-of-the-mill business insurance policy just isn't going to cut it.
Which brings us to this massive figure. The 2024 amendments capped the maximum aggregate liability for an insurance policy at an astounding 500 crore rupees per year for multiple accidents, or 250 crore for a single accident. This is a huge expansion, and it ensures the financial safety net is actually big enough to handle a modern-day industrial disaster.
But it gets stricter. Before a business can even start handling these hazardous substances, the owner absolutely must take out an insurance policy matching their total paid-up capital. Think of paid-up capital as all the money shareholders have invested in the company. This rule brilliantly forces a company to match their own financial footprint with the size of the insurance policy they hold to protect the public.
Let's hit Section 3, the Environmental Relief Fund.
So what happens if an accident is so catastrophic that the damages blow right past those massive multi-crore insurance policies? Well, enter the Environmental Relief Fund, or ERF. What you're seeing here with Form 3 isn't just boring bureaucratic paperwork. It actually mandates this incredibly smart one-to-one matching system. For every single rupee a company pays to their insurer as a premium, they have to pay another rupee directly into this central government-managed fund. This creates a powerful, centralized safety net. 90% of this fund is reserved strictly to pay out those massive excess relief awards. But the 2024 rules brought a super vital update. Up to 10% of this fund is now carved out specifically for restoring environmental damage. So it's not just about compensating people anymore, it's actually about healing the local environment that took a hit from the spill.
All right, Section 4, immediate relief for victims.
How does all this translate to tangible relief for you and me? The 2024 amendments gave a massive boost to compensation for the general public. And just to note, this is for everyday victims, as industrial workmen are covered under separate labor laws. Without any messy litigation, victims or their families get 5 lakh rupees for fatal accidents or total permanent disability. Medical expenses covered up to 1.5 lakh rupees. And if private property gets destroyed, that can trigger claims up to 50 lakh rupees. This is immediate, non-negotiable financial aid designed to keep families afloat.
And it actually drills down into day-to-day survival, too. For temporary partial disability, victims can claim up to 25,000 rupees a month for up to 3 months, just to help cover those lost wages while they're at home recovering.
Now, the real beauty of this system, speed. Victims don't have to navigate a complex tribunal first. They go straight to their local district collector. The collector runs a rapid summary procedure, basically slashing right through the usual legal red tape to verify claims and get those funds dispersed fast.
On top of that, industrial units are legally required to actively publicize these exact claim rights so affected people actually know they're entitled to this money.
Which brings us to Section 5, decriminalization and trust-based governance.
Okay, so this is where things get really interesting regarding how the government actually enforces these rules. Enter the Jan Vishwas Act of 2023. This act fundamentally shifted the whole philosophy of the law. The goal is to enhance the ease of doing business and promote what they call trust-based governance, while still remaining fiercely accountable to public safety.
It's a total paradigm shift in accountability. In the past, if a business owner made a compliance error, they faced strict criminalization. We're talking the immediate threat of going to prison. The new paradigm decriminalizes a lot of these offenses. It replaces the threat of a jail cell with heavy, scaling financial penalties. Fines can now hit up to 15 lakh rupees. And get this, by law, these baseline penalties automatically increase by 10% every 3 years, just to outpace inflation and make sure they still sting.
Finally, Section 6, regulatory oversight and appeals. Now, if we're swapping out jail time for financial penalties, oversight becomes absolutely essential. The government appoints specific adjudicating officers who wield some serious power. They can summon witnesses, demand documents, conduct inquiries under oath, the whole shebang. Once a penalty is issued, the system stays fair by letting any aggrieved party appeal to the National Green Tribunal. But they have to move fast. There's a strict 60-day window to file that appeal. Ultimately, though, the real power rests with the public because absolute transparency is baked right in. Local collectors are legally bound to maintain registers of all claim applications, awards, and payments. And anyone, whether you're a local resident, a journalist, whoever, has the right to literally walk in and inspect these registers during standard working hours. It is a fantastic way to ensure the system is actually working for the people it's meant to protect.
And that brings us to the end of our explainer. I really want to leave you with this thought. We've seen this massive shift from throwing business owners in jail to hitting them with scaling financial penalties backed by 500 crore insurance requirements and a massive relief fund. So, does this modern balance of trust and immense financial accountability truly create a safer, more responsible environment for all of us? It's a fascinating evolution of the law, for sure. Thanks for joining me on this deep dive. And as always, keep asking the big questions.